to start every session with a little reminder here, but we're on day 4. We got a lot of witnesses. We're on witness 4, and this ain't going to work. So I'm going to encourage you all to move it along. Let's control yourself, control your presentation, control your cross, or I'm going to do it for you. We're going to start limiting time. We're well within our right to do that, and we're going to do it. We're going to be very even with everybody. Everybody's will be equally opportunity offended if you need to be. But just wanted to make that statement. So with that, Mr. Willoughby, let's go. Cut your microphone on too, sir.
I understand there may be an issue about exhibit, what's the exhibit number, Joe? 41. Mr. Chairman, I think I'd move the introduction of it. If I did not, I'd now move the introduction of exhibit 41.
You did move it in, and I misstated. So we will move in exhibit number 41 into number 41.
Thank you very much, Mr. Chairman. And I have a document I'm not going to put into the record because it's in testimony, but I'm going to show it to Mr. Baldino, and I'll pass copies out to the parties in the commission as well. Chairman, this would be a demonstrative exhibit, and I do not need this exhibit marked. Now, Mr. Baldino, I'd represent to you what I just gave you is pages 11 and 12 from Mr. Hevert's direct testimony filed on August the 2nd and docket number 217-370E. Do you have that in front of you? And my guess is you probably read that as you were, since you filed testimony responding to Mr. Hevert, you probably reviewed his testimony, correct?
I did, and I've also am familiar with the Hope and Bluefield cases.
And I was going to ask you that. So you're familiar that the Hope and Bluefield cases define standards that apply throughout the United States of America, correct?
Well, I would say for me as a rate of return witness and not a lawyer that there are legal standards that inform my judgment in terms of I guess what I would call opportunity cost, which is that you want to set comparable rates of return for utilities with comparable risk.
Perfect. And so I want to let's put that up on the screen, Laura Lee, if we can. So the very first on page 11, if we look at the first quote, the very point that you raised, Mr. Baldino, is captured in that first sentence from the quotation from I believe that was the Hope case. A public utility is entitled to such rates as will permit it to earn a return upon the value of the property, which it employs for the convenience of the public equal to that generally being made at the same time in the same general part of the country on investments and other business undertakings which are attended by corresponding risk and uncertainties, correct?
That's what it says.
And do you agree that that's a correct quotation from that decision?
Yes.
And would you agree with me then that the public utility that is being defined is the public utility that is being scrutinized in an individual case, correct?
Well, the way I would put it is the Hope and Bluefield cases sort of set a legal foundation for what we as rate of return witnesses recommend to the commission for allowed return on equity. And this is an important standard that's still used today, and I'd sort of underscore part of the quotation that you read, where it says, earn a return upon the value of the property which it employs for the convenience of the public. So to me, as a rate of return witness, this really fits in with kind of what we're looking at today, and with what we're looking at with respect to South Carolina Electric and Gas Company. The value, really, of the new nuclear development costs and the value of the property which it employs for the convenience of the public. So obviously that abandoned plant's not going to be in service for the convenience of the public. So what we're here, I think what we're tasked to do here, and the Commission's taking my suggestion and taking some other recommendations as well, as to what kind of rate of return the prudent portion of those N&D costs should what kind of return it should earn.
Well, let me ask you to focus on another part of that statement. Isn't it also true that the return should be commensurate with those entities that have corresponding risk, correct?
Yes.
And if we look at the next quote further down that page, if you look at the quote from, and I think this is actually the quote from the Hope case, and the previous one was from the Bluefield case. By that standard, the return to the equity owner should be commensurate with returns on investments and other enterprises having corresponding risk. It does not say enterprises that are equal to the median investment grade utility. It says utilities with corresponding risk, correct?
Well, yes, that is correct. It doesn't specify that. You know, what we're really putting before the Commission today is what is the appropriate rate-making treatment for the prudent level of N&D costs from an abandoned plant.
But the point I make, Mr. Baldino, and you would agree with this, would you not, is that the rate of return that you've calculated of 9.1%, you've acknowledged is below the actual rate of return that the required return that investors in SE&G would have, correct?
I think that's highly likely, yes.
Thank you very much. Those are all the questions I have.
Thank you.
2 minutes. Good afternoon, Mr. Baldino. I'm Joe Reed from McGuire Woods on behalf of Dominion Energy. I have just a couple of questions for you about a statement that you made in your summary this morning to the commissioners. You referred to a decision from the State Corporation Commission of Virginia where it recently authorized a rate of return of 9.2% in a case involving rider GV. Do you recall that statement?
Yes.
Are you aware, Mr. Baldino, that the Commission in that proceeding was acting pursuant to a statute that allows Dominion Energy Virginia to recover the costs for new generation infrastructure through a separate clause?
I believe that's correct. I'd need to sort of check on that, but I believe that is correct.
Fair enough. And are you aware, Mr. Baldino, the statute in question allows for incentive adders to the rate of return to be added to the base rate of return for qualified facility?
does, and there are some other riders that Dominion, Virginia has that do have to it.
That I was going to make.
Yes.
In fact, if you know, don't the majority of those generation infrastructure riders for Dominion Energy Virginia include an 100 basis points or 200 basis points general rate of return?
I think that is accurate. Now, certainly, as I said, GV does not have that.
Correct.
And that is collecting the costs of a generating unit under construction that's a combined cycle plant. And I certainly don't think it's appropriate to add any kind of incentive mechanism to or incentive rate of return of 100 or 200 basis points to the allowable NND costs in this case.
Fair enough. Two final questions, Mr. Baudino. Are you aware what the last authorized rate of return from the State Corporation Commission of Virginia was for Dominion's base rates for generation and distribution services?
I did see that, and I just don't recall right offhand what that was.
Would you accept, subject to check, that the last authorized rate of return in Virginia for Dominion Energy Virginia's base rates was 10.0%?
I would agree with that, subject to check, yes.
Do you know what the last authorized return from the North Carolina Utilities Commission was for Dominion Energy North Carolina's electric utility services in that jurisdiction?
Subject to checking this, I think it was 9.9.
Our math is correct.
Okay.
Thank you very much, Mr. Baudino. Thank you, Mr. Chairman.
Commissioners. Commissioner Howard.
Baudino, thank you very much. Curiosity, although you said you didn't use it, what was the result of your CAP M? Did you use any other model?
The only other model I used, Commissioner, was, besides the DCF, was the CAFM, and the results I got were around 8%.
Thank you.
You're welcome.
Commissioner Elam.
So the 9.1% recommendation is just for the nuclear part of it. You're not recommending 9.1 for the entire company operations, the electric retail.
That's correct. And my portion of the case was for the ROE for the NND costs.
Okay.
But to go more fully into your question, if I was before you today on a full base rate case, I would be recommending 9.1 for the entire company.
What is the analysis you would have to do? Something that's not in your testimony now?
No, it'd be much like what was in my testimony. Yes.
Okay. Thank you.
Commissioners, any other questions? Hey, Mr. Nelson, forgot who was doing this.
I think I'm going to pass on redirect. Thank you, Mr. Chairman. I think we're done.
Okay. Mr. Baudino, thank you.
Thank you.
You may step down and you're excused.
Thank you, sir.
ORS, next witness, please.
Mr. Chairman, I would ask, could Mr. Baudino be excused, please, from appearing again at the hearing? He has a
Just
hearing in West
excused him.
Virginia. Thank you.
Mr. Chairman, Mr. Vice Chairman, Commissioners, my name is Nanette Edwards, and I'll be presenting our next witness. If Mr. Ryder Thompson, we do have summaries that we'll go ahead and hand out of his testimony. But Mr. Richardson, please state your full name, occupation, and business address for the record.
My name is Norman Kelly Richardson, Jr. My business address is 32 Dunair Court, Mableton, Georgia. Occupation is a consultant for the electric power industry.
And are you the same Norman K. Richardson, Jr., who pre-filed 12 pages of direct testimony in Docket 2017-370E on September 24th, 2018?
Yes, I am.
And do you have any edits, changes, corrections to your pre-filed direct testimony?
No, I do not.
If I asked you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
At this time, Mr. Chairman, ORS asks that the pre-filed direct testimony of Mr. Richardson be read into the record as if given orally.
Mr. Richardson's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Now, Mr. Richardson, did you also prepare rebuttal testimony in docket number 2017-305E on October 24th, 2018?
Yes, I did.
And in that rebuttal testimony, you adopted your pre-filed direct testimony in 2017-370E.
That is correct.
Okay. Do you have any corrections, edits?
No, I do not.
To that testimony? If I asked you the same questions, would your answers be the same?
Yes, they would.
Mr. Chairman, ORS asks that the pre-filed rebuttal testimony of Mr. Richardson filed in docket 2017-305E be entered into the record as if given orally from the stand.
Mr. Richardson's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Okay. Did you prepare 7 pages of rebuttal testimony in docket 2017-370E filed with the Commission on October 29th, 2018?
Yes, I did.
Do you have any edits, corrections to that testimony?
No, I do not.
Okay. If I asked you the same questions, would your answers be the same?
Yes, they would.
Okay. ORS requests that the rebuttal testimony of Mr. Richardson be entered into the record as if given orally from the stand.
Mr. Richardson's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Now, to that rebuttal testimony, did you also include one exhibit marked NKR-1?
Yes, I did.
Okay. Do you have any corrections to that exhibit?
No, I do not.
At this time, Mr. Chairman, ORS asks that exhibit NKR-1 be marked for identification and entered into the record of this case as the next hearing exhibit.
Mr. Richardson's exhibit NKR-1 will be marked for identification and entered into the record as exhibit number 43.
At this time, Mr. Richardson, did you prepare a summary of all your pre-filed testimony?
Yes, I did.
Okay. Would you please present your summary to the Commission at this time?
Yes, I will. Good afternoon, Mr. Chairman and members of the Commission. ORS determined that NND project cost incurred after March 12, 2015, which is the date of the filing by SCE&G in docket number 2015-103-E, were imprudent because SCE&G deliberately and repeatedly misled the PSC and ORS by withholding key information on the projected construction schedule, which included the decision to move forward with a thorough independent assessment of the project to be conducted by Bechtel. That assessment, which was concealed until late 2017, included projected commercial operation dates that were 18 to 36 months after the dates SCE&G filed in docket number 2015-103-E. The purpose of my testimony is to show that if the Bechtel projected commercial operation dates had been utilized in a corrected version of the analysis Dr. Lynch offered in 2015, which I refer to as the Lynch 2015 study, it would reveal that the NND project would have been uneconomic to continue. This would have most certainly prompted further investigation by ORS and might have led to a different decision than the one reached by both ORS and the Commission based on SCE&G's misleading and deceptive information. My testimony also addresses deficiencies in the economic analysis presented by Dr. Lynch in docket 2016-223-E, the Lynch 2016 study, and in this docket 2017-370-E, which I collectively refer to as the Lynch 2017 studies. My study compares the cost as of March 31st, 2015 of either 1, completing construction of the VC Summer Units 2 and 3 project on a schedule with completion dates of June 2021 for Unit 2 and June 2022 for Unit 3, or 2, abandoning the NND project and constructing 2 combined cycle gas plants of the same size with the same online dates instead. This assumes a 2-year delay on both units, which is a straightforward change to apply to the Lynch 2015 study. I estimated the construction cost associated with the delay by duplicating the projected 2016 expenditures in the years 2017 and 2018 and shifted the remaining construction expenditures 2 years. This increased the total cost of the N&D project, including allowance for funds used during construction, to $9 billion. After correcting technical errors in the Lynch 2015 study related to income taxes, cost recovery during construction, and abandonment costs, I also adjusted production costs to account for the delay and assumed that the N&D project would no longer qualify for the federal production tax credits. With these changes, the N&D project is not economically viable in any of the 9 scenarios considered by Dr. Lynch. The economic benefit of abandonment for the most likely scenario is $127 million per year for 40 years. Although Dr. Lynch stated in his testimony that the break-even point for abandonment would be around $9.9 billion in total construction cost, this did not consider a delay in the online dates, which is a significant factor. In his rebuttal testimony, Dr. Lynch stated that SCE&G considered the cost associated with the delay the following year. The result was an increased cost of $84 million per year, which is far less than Mr. Richardson's calculation. However, that analysis included fixed EPC cost and penalties that were only introduced with the fixed-price EPC offer that SCE&G accepted on May 26, 2016. When those penalties are removed, since they did not exist at the time of the Lynch 2015 study, the increased costs are consistent with the ones I projected. I also performed an alternative analysis using the earliest possible dates from the Bechtel report, which would place Unit 2 in service in December 2020 and therefore qualify for the federal production tax credit. In this alternative analysis, the most likely scenario cited in the Lynch 2015 study shows that abandoning the N&D project and replacing with the combined cycle alternative results in an economic benefit of $55 million per year over 40 years. 8 of the 9 scenarios using the base load forecast show an economic advantage over 40 years for abandoning the N&D project, with the 9th scenario, including the highest gas and carbon prices, breaking even after 30 years. The Lynch 2016 study concluded that the economic benefit of continuing with the N&D project increased as compared to the Lynch 2015 study, even though natural gas prices decreased, carbon prices were delayed and decreased, and the project was delayed with an increase in the remaining cost to complete. This study included 2 significant errors which overstated the benefit of completion. The first one is that the sunk cost of abandonment included 9 months of forecasted future expenditures that had yet to be made and did not include accumulated deferred income taxes. The second one is that all carbon costs for the N&D project alternative were incorrectly set to 0 in an attempt to compare a rate-based carbon program to a mass-based carbon program assumed for the natural gas alternative. When these errors in the Lynch 2016 study are corrected, the most likely scenario shows that continuing with the NND project is no longer economic, even without considering the projected Bechtel dates for completion. The Lynch 2017 study corrects the sunk cost error that was part of the Lynch 2016 study, but still has the same problem with the carbon cost calculation. When correcting for this, none of the alternatives for continuing with some or all of the NND project are economic. This concludes my summary.
Thank you. Mr. Chairman, Mr. Richardson's available for cross-examination and questions from the commissioners.
Thank you. Okay, we'll take cross-examination. Mr. Gile?
Mr. Chairman, I have no questions. Thank you, Mr. Richardson.
Other parties? SE&G?
Mr. Richardson, I'm Belton Ziegler, representing SCE&G. A few questions for you. This is your first appearance before this commission, is it not?
Yes, it is.
And I take it that you have I take it you've reviewed the past orders that relate to this project in preparing your testimony.
I've reviewed the ones that are relevant to the 2015 and 2016 cases.
Did you review the 2009 order?
No, I did not.
Would it surprise you to learn that in the 2009 proceeding, there was an expert in utility forecasting that was hired by ORS to review Dr. Lynch's studies and methodologies in that case?
That wouldn't surprise me, no.
It wouldn't surprise you. That's good, because they in fact did. And you understand, don't you, that under the Baseload Review Act, ORS has the ability to hire any experts that it wants for these proceedings and charge the costs to SC&G. Are you aware of that?
I'm aware that they have that ability, yes.
And in fact, they're charging your costs to SC&G as they charge the cost of the prior expert to SC&G.
For my cost, that is correct, yes.
That's an expert named Dr. Zhu, I think, Z-H-U. I think he's also from Atlanta, but you may not know him. And he did a thorough review of Dr. Lynch's analysis and found them to be correct. Would you be surprised to find that be the case?
No, I would not be surprised.
Let me ask you, if you would, to look at what is going to be put up here, which is the order that was issued in that proceeding. And if you could put that up for me and refer to, Dan, the page that we highlighted. I believe it is page 12. I do not have it written down here, I'm afraid. Your Honor, I believe all of the orders were entered into the record in this case, all the prior orders. While he's finding that particular point, you also are aware that under the general statutes that apply to the Office of Regulatory Staff, ORS has the right to request any information, audit any information, or inspect anything that it wants that's operated by an electric utility in South Carolina. Are you not?
I'm aware that ORS has the ability to issue audit information requests for that information.
And that's a general power that applies to all of its activities in regulating utilities in South Carolina. Is that correct?
As far as I know.
All right, sir. So there was no reason that Dr. Zhu would be limited in the information he could have in making his analysis, would there?
There'd be no reason that I know of.
And are you aware that the opinion in the commission order in that case was appealed to the South Carolina Supreme Court, who found that there was copious evidence supporting the decision to build nuclear based on Dr. Lynch's studies?
No, I'm not aware of that.
Very good. Now, you referenced two particular cases in which Dr. Lynch provided studies, 2015 and 2016. ORS did not hire an expert in any of those cases, did it?
I'm not aware of any that was hired for that purpose.
You read the orders. There was no evidence presented on that.
There was no testimony offered. That's correct.
Correct. And in fact, the same is true for 2012, which is the other case in which Dr. Lynch appeared and presented his financial analysis. Is that true?
I have not reviewed the 2012 case.
In any case, we are now, with the benefit of hindsight, coming back and saying Dr. Lynch should have done things differently. Is that correct?
No, I would not classify it as hindsight.
All right. Well, let's talk about that for a second then. Dr. Lynch's studies were done at a time when it was not clear that there would be a $1.02 billion guarantee payment from Toshiba. Is that correct?
The 2015 and 2016 studies did not include the Toshiba settlement, if that's what you're asking.
And that's because there wasn't a basis under the EPC contract for SCE&G to claim that Toshiba should make that payment. Is that correct?
That's my understanding.
In fact, SCE&G would have had to pay SCE&G and Santee Cooper about $500 million to Westinghouse had they walked away from the contracts at that time. Isn't that correct?
I do not know that.
Well, I think if you look at Dr. Lynch's studies, I would ask you, have you looked at them to see if that's part of his analysis?
That particular aspect was not part of the 2015, 16, and 17 analysis that I reviewed.
We'll ask Dr. Lynch about that when he's on the stand. But isn't it the case that Dr. Lynch took the costs they'd have to pay to Westinghouse and the consortium to breach the contract, and they subtracted from that the salvage value of the equipment and materials and the value of what was on the site, and came up with a number which was used to determine the net cost of getting out of the EPC contract?
That is correct.
That is correct. And that is a different approach than asking for an abandonment deduction, correct?
I'm not sure what you mean by asking for an abandonment deduction.
Well, if you're receiving value for the assets, if you're salvaging them, you're not abandoning them, correct?
If my understanding of Dr. Lynch's analysis, only a small portion of the project was salvageable and deducted from the cost. The rest were considered to be abandoned.
Well, I think you testified that you hadn't really looked at that set of issues about the $500 million netting the abandonment against the salvage value, but we'll take that.
I don't recall that amount was actually listed.
All right. And so in your analysis, you take issue with Dr. Lynch's including of production tax credits in the analysis that he made in 2015 and 2016. Is that correct?
I don't take issue with him including them with the scheduled dates that he also assumed. That would be consistent with the scheduled online dates that he assumed for his analysis.
All right. So you're assuming that the construction was delayed such that the PTCs would not be earned, if I can use PTC as the abbreviation for production tax credit.
That was what my analysis showed, yes.
All right. Now, are you aware that the limitations, the deadlines for achieving the PTC payments have now been removed by the federal government?
Yes, I am aware of that.
All right, sir. And are you aware that beginning in 2014, SCE&G was actively working with its congressional leaders to have that take place?
I was not aware of that until Dr. Lynch included that in his rebuttal testimony.
All right, sir. So you would understand, though, that this would apply both to South Carolina and to the Vogel project if that were done, correct?
That's correct.
And so that would mean that it would be something that would be of very much importance to Southern Company, which owns Vogel, correct?
Which owns the majority
of Vogel. Actually,
the plurality.
The plurality, that's right. So Southern Power is Georgia Power?
Georgia Power is a wholly owned subsidiary of
Alabama Power?
And as well as Alabama Power and Mississippi Power. And for
Gulf,
a little while, Gulf Power.
Recently Gulf Power, and that includes Florida, correct?
The Panhandle of Florida, correct.
And also owners in that project and interested in the PTC issue was City of Jacksonville, another Florida entity, correct?
Indirectly through the Municipal Electric Authority of Georgia, that's correct.
Right, MEAG. And so the MEAG represents a broad group of Georgia municipalities who would have an interest in getting the PTC deadlines removed, correct?
That is correct. Well, it's a little bit different for a non-taxable entity like MEAG and Oglethorpe, but they would have an interest in that.
That's a very good point, because part of the proposal from the beginning was to both remove the deadline and make it possible for the MEAG participants to monetize their production tax credit allocations, correct?
That's my understanding.
So there were two reasons why they wanted it done. And the same would be true for the city of Dalton, which was part of the process outside of MEAG, and Oglethorpe Power, which represents a great number, if not all, of the co-ops in Georgia. Is that correct?
Almost all of the co-ops, correct.
And the same would apply to Santee Cooper and the South Carolina co-ops, correct?
Correct.
So that group was actively trying to get this deadline removed. Does it surprise you that that was actually accomplished?
Does it surprise me that the legislation was passed removing that?
Mm-hmm.
Not in light of the Westinghouse bankruptcy, no, it does not. It surprised me.
Do you think the Westinghouse bankruptcy is that your testimony? That's what caused this to happen?
That was the
caused the legislation to pass?
That was the trigger point that enabled that legislation to pass. That's very likely.
But you wouldn't deny that the process had been in motion for a number of years to build a consensus to remove the PTCs, and that process was ongoing in 2015.
I was not aware of that because I had read nothing to that effect. So if it was ongoing, I didn't know about it or had seen anything about it.
All right, sir. And it's also the case, isn't it, that part of what we know now that we didn't know then is that SC&G would have this option to purchase 540 megawatts of combined cycle capacity to replace the majority of the capacity that would come from building these units. Is that correct?
I don't know if that is correct or not.
Well, the Columbia Energy Center is a 540 megawatt entity that SC&G has purchased only quite recently. It was one that was purchased out of the an entity that was in financial difficulty. And you understand that one of the proposals is that given the very low purchase price of that, in light of that, SC&G is going to give that unit into its generation system with no capital cost to customers.
That is my understanding, yes.
And that was not known at the time these studies were done. Let me ask you this. In doing your study, you took, in order to quantify the 2-year delay, you took the expenditures from 2016 and, in effect, doubled them for 2 years and added 2 more years of expenditure at that level to the project. Am I reading your testimony correctly?
That's a fair assessment of what I did. That's
all right, sir. And you are aware that in 2015, more than 60% of the price of the units was a fixed price, correct?
I was not aware of that, no.
Under the EPC contract, well, let's say, if that were the case, then you would be doubling costs that would only have to be paid once. Is that correct?
To the extent that they were truly fixed, that would be correct.
And the record, I think, will speak very clearly to that. Now, have you familiarized yourself with the work that went on in the various task forces and with the Department of Health and Environmental Control in South Carolina concerning how to handle the emissions limits from the Clean Power Plan? Are you familiar with that process in South Carolina?
I'm only familiar with it to the extent that I read about it in various news articles.
And you're aware that people like Joe Lynch were involved in that on the ground when it was taking place?
That would be my assumption, that any utility involved in resource planning was looking at that extensively.
And it was a conclusion of that group, I believe the record would show, that South Carolina could meet the Clean Power Plan if these units were built and pay zero carbon cost if it did it under a rate-based plan. Is that your understanding?
That's not my understanding. My understanding was there was an analysis done that showed that the rate-based would be the most favorable.
Correct. And it actually showed, I believe the testimony will show, and we will verify this, that the rate-based plan would create valuable credits above and beyond the zero level for South Carolina, since the non-emitting nuclear power would be creating credits that could be sold to other states. Would you dispute that would be a possibility?
I don't doubt that would be a possibility.
All right, sir. And so would there be any reason for South Carolina to not go with a rate-based plan if they could actually turn it into a plus in light of nuclear construction?
Well, I would say that the decision whether to advocate for a mass-based or a rate-based type of structure would involve a comparison between the two, and whichever one produced the biggest economic benefit to the state would be the one that should be selected.
Those are all the questions I have, Mr.
Thank you, Mr. Ziegler. Mr. Reed? No question. Commissioners? Commissioner Whitfield.
Thank you, Mr. Chairman. Good afternoon, Mr. Richardson.
Good afternoon.
Just one quick question related to what Mr. Ziegler was just asking you. Of course, we know the production tax credits have been extended. Do you think the more strict air emission standards will be implemented?
If you're asking if I believe that we'll see either a tax or a program to limit carbon emissions in the future, yes, I think it's likely that at some point in the future that will happen. It seems unlikely that it would be in the near-term future, meaning within the next 8 to 10 years.
Thank you. One other question, not directly your purpose of your testimony, but I noticed in your testimony you state that your experience includes providing testimony to the Wisconsin Commission and the Michigan Commission and I think Hawaii. And you testified in rate case filings in some of those other states. Could you share from your experience and your previous testimony how the rates here stack up, both previously the current experimental rate that the company is operating under and the proposed optimal plan that ORS is offering today?
I have not directly studied or looked at the rates specifically within South Carolina. However, as part of those and some other work that I've been involved with, one of the things I've reviewed is the average rate by state. And in fact, if I recall correctly, after or at the beginning of last year, South Carolina was the second highest behind only Hawaii, if I recall that correctly, where Hawaii relies almost strictly on imported oil and renewables for its power generation supply.
How does the current rate stack up? Would you be able to answer that?
I have not looked at that recently. It's not something I've looked at recently, no.
All right, thank you. That's all I have, Mr. Chairman.
Mr. Chairman, I have one question.
Mr. Williams.
Thank you, Mr. Chairman. Mr. Richardson, based on your analyses, if SCENG could still get production tax credits and receive carbon benefits with completion dates of 2021 and 2023 for units 2 and 3 respectively, will the units be economic?
Not with the current level of gas prices, no, it would not.
Okay. Thank you.
Thank you, Commissioner Williams. Hey, Ms. Edwards, any redirect?
Redirect.
Okay. Hey, Mr. Richardson, thank you. You may step down and you are excused. Next witness, ORS.
Thank you, Mr. Chairman. ORS would call this next witness Mr. Calvin Major. Afternoon, Mr. Major. Can you please state your full name and occupation for the commission?
My name is Kelvin Leonard Major.
Get close to that microphone, Mr. Major.
Yes, sir.
And speak up.
My name is Kelvin Leonard Major. I'm employed as an audit manager with the ORS.
Before we even get started, have you testified in front of this commission before?
Once before.
Once. Okay, thank you. Are you the same Calvin Major who pre-filed 8 pages of direct testimony in docket 2017-370E on September 24th of this year?
Yes, sir.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
I do.
Please provide them to us.
The following changes are made to my direct testimony. On page 1 of 8, line 1, direct testimony should read direct testimony and exhibit. And also on page 6 of 8, line 4, following this amount, the sentence should read See Exhibit KLM-1. Those are my corrections.
Thank you. Mr. Chairman or Mr. Butler, we would intend to file a rata sheets with the commission. We'll just file those afterwards with these changes noted. Do you have any, with the exception of the changes he stated, if I asked you the same questions today as those provided in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
We would ask that the pre-filed direct testimony of Mr. Major, as corrected from the stand, be read into the record as if given oral.
Pre-filed direct testimony of Mr. Major, as corrected, will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Major, did you also file rebuttal testimony in docket 2017-305 on October 24th, in which you adopted your pre-filed direct testimony and exhibit in docket 2017-370?
Yes, I did.
Do you have any changes, edits, or corrections to your rebuttal testimony?
I do not.
I asked you the same questions as those stated in your rebuttal testimony today. Would your answers be the same?
Yes, they would.
Thank you, Mr. Chairman. ORS would ask that the pre-filed rebuttal testimony of Mr. Calvin Major be entered in the record as if given orally from the stand.
Mr. Major's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, sir. Mr. Major, do you file or cause to be filed on your behalf on October 25th an exhibit marked as KLM-1 as an attachment to your pre-filed direct testimony?
Yes, I did.
Do you have any changes or edits to that exhibit?
No, I don't.
Thank you. Mr. Chairman, ORS would offer exhibit KLM-1, which was filed with the Commission October 25th, as the next hearing exhibit.
Exhibit KLM-1 will be entered as Exhibit 44.
Thank you, Mr. Chairman. Mr. Major, do you prepare a summary of your direct and rebuttal testimonies in these dockets?
Yes, I did.
Will you please present it for the Commission?
Good afternoon, Mr. Chairman and members of the Commission. My testimony describes the procedures used to determine the allowable incremental new nuclear development construction work in progress and each revised rates proceeding, as well as the allowable CWIP balance for South Carolina Electric and Gas Company. ORS obtained transaction-level detail for all new nuclear development and transmission charges to CWIP each month, sampled those transactions, and tested the invoices provided as support for those samples using established criteria for rate-making purposes. The non-allowables resulting from the transaction tested were deducted from the CWIP balance. The gross cost of capital percentage and retail allocation factor were then applied to the ORS allowable CWIP and the corresponding AFUDC to produce the incremental allocated retail revenue requirement for the year. In order to calculate the allowable CWIP balance as of the March 12, 2015 cutoff date, ORS added the 12-day prorated balance of CWIP expenditures incurred during the month of March 2015, less any adjustments ORS made in the previous rate proceedings to the CWIP balance at February of 2015, resulting in a balance of $2,865,679,745. ORS further reduced this amount by $19,943,940 to reflect the removal of expenditures incurred through March 12, 2015 for all SCE&G bonuses allocated to NND, consultant fees, company adjustments contained in SCE&G witness Cocum's testimony at exhibit number KRK-1, and costs related to the fraudulent procurement activity discovered by ORS's review of documents provided by the company. After removal of these additional expenditures, ORS's allowable CWIP as of March 12, 2015 totals $2,845,735,805. My testimony also discusses ORS's recommendation regarding the treatment of the future sale of equipment and materials and the exclusion of transmission costs in the calculation of allowable CWIP. This concludes my summary.
I believe you're not on.
Mr. Chairman, Mr. Major is available for questioning, for cross-examination or questioning by the Commission.
Okay, thank you. Okay, cross-examination. Mr. Guile.
Thank you, Mr. Chairman. Good afternoon, Mr. Major.
Good afternoon.
Question or two for you. In your course of your duties, have you had occasion to research whether or not SCE&G made any payments to the Bechtel Corporation between August 2015 and February 2016?
Yes, I have.
What did that research demonstrate?
The research showed that SCE&G made payments in August of 2015, January of 2016, and February of 16, totaling $1 million to Bechtel Corporation.
Were these payments to Bechtel Corporation made directly to Bechtel or to a law firm?
Those payments were made directly to Bechtel.
And during that period, did SCE&G make any payments to the law firm Smith, Curry, and Hancock?
Yes, they did also.
And in what amount were those payments?
Those payments varied in amount. Here I have before me totaling $104,000.
All right. Did you happen to bring with you a document reflecting a printout of the work order database that reflects the payments you've just identified?
Yes, I did.
Can I ask counsel to perhaps distribute a copy of that, if you have extra copies of that?
Yes, sir. I would also note that this somewhat redacted for the second portion of this.
Mr. Major, would you just describe what the document is that's before you that you just referred to?
The document is what we call work order data. It's a detail of the construction work in progress account that we receive monthly from the company. Document lists all the expenses that the company, the expenditures monthly. Before me, I have 3 items highlighted where the Bechtel payments were made.
I'll just get you to hold up 1 second until the members of the commission have copies of the document. Before you speak to the content of the document, is this a document that was prepared by you or under your supervision?
Yes, it was.
And tell us one more time clearly what the source of the information is that's displayed in the document.
The source of the information comes directly from the company. This is the work order data or detail of the monthly expenditures that are attributable to the CWIP account.
And is this an accurate depiction of that information provided to you by the company in the course of your audit duties to the best of your knowledge?
Yes, it is.
Mr. Chairman asks that this document be identified as the next hearing exhibit and received in evidence.
This will be entered as exhibit number 45. Mr. Major, I've been asked to get you to make sure you speak into that microphone.
Payments, Mr. Chairman.
Yes, sir.
Mr. Major, the payments that you referred to earlier, are they highlighted in yellow?
Yes, they are.
And again, those are the payments directly to Bechtel, amounting in total, those 3 payments, to $1 million even?
Yes, sir.
How did SCE&G identify or code these 3 payments totaling $1 million to Bechtel?
These payments are coded by resource code to other outside services, 501.
All right. Is there a code that SCE&G could have used for these payments had they been payments designated as consultant work or legal work?
Yes, sir.
How would they designate it in that instance?
Legal work is coded to resource code 528.
And how about professional consulting?
I'm not quite, I don't have that with me right now, but it would have been another code associated with that.
Not the code employed by SCE&G, that is 501 for these expenditures, correct?
Yes, sir.
And can you tell whether or not SCE&G paid these sums, $1 million during that period, directly to Bechtel as opposed to through an attorney?
As it appears in the work order data by vendor name, the payment was issued directly to Bechtel.
Now, aside for the 3 payments that you've identified totaling $1 million, did Bechtel receive other payments from SCE&G for work during the period that this project was underway, years 2013 through 2017?
Yes.
And in what aggregate amount, aside from the $1 million payment, was Bechtel paid for project work during those periods?
In aggregate amount, we totaled approximately $6.2 million.
So the $1 million payment during the narrower period of time I asked you about earlier, the amount of money we understand was the cost of the Bechtel project assessment at issue in this case. Did that strike you as an unusual amount of payment as compared to the total of work being billed to Bechtel during the entire project period?
No, sir.
So in that respect, would that $1 million, 3 payments totaling $1 million, have drawn your particular attention as an auditor for ORS?
No, sir, it would not have.
Now, were the 3 payments totaling $1 million to Bechtel Corporation for that assessment, were they passed on to ratepayers in this case?
Yes, they were.
And how can you tell that?
They were included in the work order data for this period, which would have assigned them to the 2016 proceeding.
All right. Thank you. That's all I have.
Thank you. Other cross, other parties. SENG.
Couple of questions, Mr. Major. Belton Ziegler, representing SCE&G.
Yes, sir.
And I certainly don't want to embarrass you in any way, but obviously it wasn't just happenstance that you had the exhibit that Mr. Guile was looking for when you came to testify today. Is that correct?
Happenstance? What?
You understood he was going to come up and ask you these questions. You were prepared and someone had made that possible.
I would object to this as being protected under common interest agreement between certain other parties.
Sustained.
All right. Mr. Major, I just want to be sure I understand the process that you all went through and ask you a couple of questions about Bechtel.
Yes,
now, you understand that when SCG was preparing its application in this matter and dealing with environmental concerns, Bechtel was its environmental consultant. Are you aware of that fact?
I'm not aware of that fact.
All right. So you weren't aware that Bechtel had worked on the project before this? Before 2014, 2015.
As an auditor, I'm not an expert on that area of it, so I'm not concerned with the actual Bechtel in that sense.
But Mr. Guile made the point that you were aware of Bechtel having worked on the project, and therefore it wouldn't seem to be unusual. But I think you just said you didn't realize Bechtel had worked on the project before this. Is that correct? Before these transactions?
Could you rephrase that?
Well, I asked you, were you aware that Bechtel had worked on the project as an environmental consultant when the application was being presented and the environmental issues were being handled? And you said you didn't know that.
I was not aware that Bechtel worked as an environmental consultant on the project. No, sir.
So when Mr. Guile asked you, were you surprised to see Bechtel, and you said no, that you knew that they were consultants on the project, that wasn't strictly accurate, was it?
I was not aware that Bechtel was an environmental consultant on the project.
All right, sir. All right, sir. So, and again, Chairman, we won't belabor these matters. I think the point's made very well. Now, if I understood your testimony correctly, every month, SC&G provided you a ledger that showed all the expenditures, every payment that was made on this project. Is that correct?
Yes, sir.
And that would be a thick document, wouldn't it?
Yes, it would be.
How thick was it typically?
Very voluminous.
I mean, just give me 6 inches, a foot?
It's not printed, it's in electronic format.
I see. Okay, so a very, very thick electronic document. Mm-hmm. And every single piece of money that was going to the project was reflected there, every payment, correct?
To my knowledge.
And you were given the opportunity to look through that list and pick as many of those items as you wanted to look at and ask SC&G to give you the supporting documentation. Is that correct?
Yes, sir.
And they would provide you that documentation, correct?
They would provide that documentation.
And if that led to other questions, you could ask for other documentation, and you could follow that also, correct?
Yes, sir.
And even things as sensitive as the Smith and Curry legal bills were put on that ledger, weren't they?
Yes, sir.
It was absolutely comprehensive. And And so you could have picked any of the things that you saw here and asked for full detail on that. Is that correct?
Yes, I could have.
And as a result of that, you looked at the appropriateness of all of the expenditures that were made from the life of the project, you being the ORS, through its termination, correct?
I myself did not look at through the life of the entire project, but I did not.
ORS did. ORS had that right. And that's what it means by auditing the project, correct? You were looking at the documents, looking at the ledgers, pulling documents, and following down. So, were you here when Mr. James and others talked about SC&G's extraordinary efforts to conceal Bechtel's involvement with the project?
No, sir, I was not.
Okay. Mm-hmm. So you would agree that it's hard to conceal something when you're basically opening up every transaction in the project to auditing and inspection by the person you're trying to conceal something from, isn't it?
I stand with Mr. James's testimony.
Very good. No further questions, Chairman.
Thank you, Mr. Ziegler. Mr. Reed?
No questions.
Thank you. Commissioners? Commissioner Urban?
Thank you, Mr. Chairman. I believe on page 3 of your direct testimony, you state that ORS requested additional supporting documentation concerning the consulting work performed by Mr. Timmerman, the former CEO for SCANA or SC&G. Is that correct?
Yes, sir.
Did you receive additional information regarding Mr. Timmerman's work?
No, sir, I did not.
Why?
I don't have that answer. We made the request, but we didn't receive any additional information.
Well, did he have a contract with the company?
Yes, sir.
Do you have a copy of the contract?
I don't have one available with me, but I'm sure we can produce one if necessary. Or from.
Is it part of our record? Do you know?
No, sir.
I don't believe so, Commissioner. If necessary, I can't say that I've necessarily seen that document. I don't know for certain that we have a copy.
If you have one, could you produce it?
If I have one, sir.
All right. Would you check for us?
Sure.
Were you able
You
to?
want to get a late file exhibit?
Yes, sir. Please.
Okay. We'll ask for that on a late file exhibit and have that as number 46. Yes, sir.
Chad Burgess on behalf of SC&G. Just for a point of order, that contract was filed with the Securities and Exchange Commission. It is available for K.
Yeah, get that. Sorry about that. Get that microphone.
It's okay.
So we
Chad
can hear.
Burgess for SCE&G. Mr. Timmerman's contract was filed with the SEC as an 8K filing, and it's available, so we can link to that if that would be preferable.
Thank you.
Good. Thank you.
It'd be helpful if we had it as part of our record.
Yes, sir.
Since you may not have it, either way, we'd like to have a copy for our record. But you had no supporting documentation. You were not able to determine whether there was any, or were you told there was none? Which is it?
We did not receive any, sir.
Well, did you receive any explanation about why you didn't receive it?
We were pointed to, if I remember correctly, we were pointed to the information in the 8K and nothing else from there.
Were you not curious about what supporting documentation might be available?
Yes, sir. We requested, we asked for any available timesheets, any records, or any reports made by Mr. Timmerman, any possible expense forms he may have filled out for reimbursement, things of that nature, and we did not receive any of those things.
Did you get any explanation
From
the company? In other words, did they say don't exist, or did they say they're not available at this time? Or I'm just curious what their response was. Or was there a response?
In reference to the to timesheets and records of that nature, if I recall correctly, Mr. Timmerman, I want to paraphrase the contract, but if those amounts were, let me start back over. In reference to the contract, Mr. Timmerman would be able to fill out timesheets accordingly if required by the company. When asked upon the company whether timesheets were filled out, they said it never required it.
So the company never required any documentation. Is that your understanding?
Yes, sir.
Thank you. No further questions.
Thank you. Commissioners? Commissioner Elam?
Good afternoon.
Good afternoon, sir.
Page 2 of just your summary that you provided at line 8 that says ORS further reduced this amount by almost $20 million to reflect the removal of expenditures incurred through March 12, 2015 for all SC&G bonuses allocated to NND. Were SC&G bonuses in rates prior to 2015?
Yes, they were.
Thank you.
Mr. Hamilton?
Thank you, Mr. Chairman. Major, welcome back.
Thank you, sir.
Mr. Major, you're aware that OS is seeking the optical plan for the settlement in this case?
Yes, sir.
Are you familiar enough with it that you could tell me if this goes forward, what will be the status of SC&G financial status?
No, sir, I'm not familiar with it to tell you that status, but I do support the ORS optimal plan.
Thank you, sir.
Thank you.
Commissioner Whitfield?
Thank you, Mr. Chairman. Good afternoon, Mr. Major.
Good afternoon, sir.
Just a quick question here for you regarding question Mr. Ziegler had for you about some of these itemized expenditures to Bechtel. There's, I think you had stated that you weren't aware they were the environmental, had done environmental work on the site. You were not aware of that, right?
No, sir, I was not aware of that.
There's some expenditures above the yellow from it's like latter part of 2013, very first part of 2014 for licensing and engineering support, maybe?
Yes, sir.
Was that, what type of licensing are they referring to? Environmental or other, do you know?
No, sir, I do not. I do not.
So, and that's obviously a couple of years before these Bechtel payments for the report were done that was done for the law firm.
Yes, sir.
So, but you had seen these in the ledger previously.
Yes, I myself or someone in my capacity would have seen those in the ledger. We'll have the opportunity to see those in the ledger.
Okay, and there's some even before that, and you don't know what those are for either. I think says year 2011 service to provider, maybe. I can't quite make it out, but you're not certain what those
others are for?
Oh, yes, sir.
No, sir.
Okay. Thank you, sir. That's all I have, Mr. Chairman.
Thank you.
Commissioners, any other questions? Mr. Nelson, any redirect? I've heard that before.
Hello again, Mr. Major. How many entries per month did you typically review?
Typically, we review 80 entries per month.
Okay. Out of how many that were provided to you on an average month, do you think?
That number would be, it varies, but it would be certainly larger.
Talking thousands?
I would say within the thousands.
Okay.
Yes, sir.
And did you verify as part of the procedure of your verification? Tell us what exactly you did. Did you actually verify the costs or the prices of these items and check it against market prices and that type thing?
No, sir. We review them for mathematical accuracy, strictly at that level. Mathematical accuracy related this to the N&E project to ensure that they were coded to the correct cost codes, and things of that nature.
So you basically balanced the invoices against payments. Would that be correct?
Yes. Mm-hmm.
Thank you. And are we clear on the other Bechtel entries there? Did you review those entries at any point?
No, sir. I did not review those.
All right. And because why would that be? They just weren't part of the selection?
They were not part of the judgmental sample that was selected.
Okay. Thank you. No further questions.
Thank you.
Thank you, Mr. Nelson. Now, any recross of Mr. Nelson's questions? Okay. Thank you. Mr. Major, thank you. You may step down. ORS will take your next witness.
Thank you, Mr. Chairman. ORS would call Daniel Sullivan as its next witness. Can Mr. Major be released?
Sure.
Sooner. What was our treatment, if I may ask, what was our treatment with respect to the Timmerman contract? Were we going to get a late file exhibit? Is it going to be a link or a document? Doesn't matter. I just would like my notes to reflect.
I believe I heard a link offered. Was that true, Mr. Burgess, or were you going to provide a document?
We can print the SEC filing. The point I was making is that it's publicly available. It's on the SEC's website via EDGAR.
Commissioner, what's your preference?
I would prefer a written document that we can place in evidence, if you don't mind. Could you do that for us? Thank you very much.
Thank you.
Thank you, Mr. Chairman. Sorry to interrupt.
That's okay. Thank you.
Mr. Sullivan, can you please state your full name and occupation for the commission?
Daniel Sullivan, employed by the Office of Regulatory Staff as the Deputy Director of the Audit Department.
Are you the same Daniel Sullivan who pre-filed 9 pages of direct testimony in Docket 2017-370 on September 24th this year?
Yes, I am.
Do you have any changes, edits, or corrections to your pre-filed direct testimony in that case?
Yes, I do. I have 2 sentences in my direct testimony that I'd like to change. Again, this is my direct testimony, page 2 of 9, lines 17 through 21. As filed, it reads, in Step 1, ORS verified the per-books operating experience and rate base reported by SCNG in its quarterly report, and that the application for the various cost recovery plans were supported by the accounting books and records for the 12 months ended September 30th, 2017. That sentence should read, in Step 1, ORS verified the per-books operating experience and rate base reported by SCNG in its quarterly report, and the application for the various cost recovery plans were supported by the accounting books and records for the 12 months ended September 30th, 2017. Basically, I removed the word that from line 19. Second sentence to correct. Again, direct testimony, page 7 of 9, lines 11 through 13. As filed, it reads, therefore, returns computed net of these impairments are inflated because they are returns based only on the portion of the capital investors who have invested in SCNG's electric utility system. That sentence should read, therefore, returns computed net of these impairments are inflated because they are returns based only on a portion of the capital investors have invested in SCNG's electric utility system. There, my corrections are line 12, I changed the word the to a, and on line 13, removed the word who.
Thank you. And as with Mr. Major, we'll file an errata sheet with those corrections with the commission. Now, Mr. Sullivan, if I asked you those same questions, other than the changes you've just noted, if I asked you the same questions as those presented in your pre-filed direct testimony, would the answers today still be the same?
Yes, they would.
Or else would I ask that the pre-filed direct testimony of Mr. Sullivan be read into the record as if given orally from the stand?
Mr. Sullivan's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Mr. Sullivan, do you also file as an attachment to your direct testimony one exhibit which you had marked DFS1?
Yes, I did.
Do you have any changes, edits, or corrections to that exhibit?
No, I do not.
Thank you. Mr. Chairman, ORS would ask that exhibit DFS1, which is attached to Mr. Sullivan's pre-filed direct testimony, be marked for identification, entered in the record as the next hearing exhibit.
Mr. Sullivan's exhibit DFS1 will be marked and entered into the record as exhibit number 47.
Thank you, Mr. Chairman. Mr. Sullivan, did you also file rebuttal testimony in docket 2017-305 on October 24th, in which you adopted your pre-filed direct testimony in docket 2017-370?
Yes, I did.
Do you have any changes, edits, or corrections to either your rebuttal testimony, to the testimony that you filed under 2017-305?
No, I do not.
If I asked you the same questions today as those presented in your testimony there, would your answers be the same?
Yes.
Mr. Chairman, ORS asks the pre-filed rebuttal testimony Mr. Sullivan filed in docket 2017-305E be entered in the record as if given orally from the stand.
Mr. Sullivan's rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. And lastly, Mr. Sullivan, did you also prepare 4 pages of surrebuttal testimony in all 3 of these dockets, 2017-207, 305, and 370, which were filed with this commission on October the 29th?
Yes.
And do you have any changes, edits, or corrections to your pre-filed surrebuttal testimony?
No, I do not.
Mr. Chairman, ORS would ask that the pre-filed surrebuttal testimony of Mr. Sullivan be read in the record as if given orally from the stand.
Mr. Sullivan's pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Mr. Sullivan, do you also file as an attachment to your pre-filed surrebuttal testimony a 6-page exhibit marked as Surrebuttal Audit Exhibit DFS1?
Yes, I did.
Do you have any changes, edits, or corrections to that exhibit?
No, I do not.
Mr. Chairman, ORS would ask the pre-filed exhibit identified as Surrebuttal Audit Exhibit DFS1 and filed with Mr. Sullivan's pre-filed surrebuttal testimony be marked for identification, entered into the record as the next hearing exhibit.
Mr. Sullivan's surrebuttal exhibit will be entered into the record as exhibit number 48.
Thank you, Mr. Chairman. Mr. Sullivan, did you prepare a summary of all of those testimonies?
Yes, I did.
Would you please present them for the commission?
Sure. Good afternoon, Mr. Chairman and members of the commission. My direct and surrebuttal testimonies set forth ORS's findings and recommendations resulting from our examination of the joint application and petition of SCNG and Dominion Energy. The ORS Audit Department verified the per-books operating experience and rate base in the joint application and reported by SCNG in its September 30th, 2017 quarterly report. ORS performed a limited review of SCNG's per-book figures and accounting and pro forma adjustments since the joint application did not seek an increase in base rates and only sought approval of a business combination between SCANA and Dominion and a prudency determination regarding abandonment of the NND project. The net income for return, rate of return, and return on equity as of September 30th, 2017 in SCNG's quarterly report are not accurate representations of SCNG's current electric operations. My testimony recommends that the Commission require SCNG to absorb and not recover from ratepayers any sales and use taxes paid as a result of the South Carolina Department of Revenue's assessment on the NND project. In addition, based on the ORS Optimal Plan, all costs incurred after March 12, 2015 are not included in the prudently incurred ORS NND project construction work in progress balance. My testimony also notes that as of September 30, 2017, SCNG's non-NND project retail electric gross plant service has increased by approximately $1.26 billion since its last base rate case in 2012. This additional gross plant service has not been considered in the determination of SCNG's current non-NND project base rates. My surrebuttal testimony responds to the rebuttal filed by Mr. Cocombs and Ms. Griffin. It addresses an adjustment made by ORS for bid rigging by a vendor associated with NND project, the South Carolina Department of Revenue Sales and Use Tax, and reliance on SCNG's exhibits as an accurate financial representation of electric operations.
Thank you. Does that conclude your summary?
Yes, it does.
Mr. Chairman, Mr. Sullivan is available for cross-examination by the other parties or for questions from the Commission. Thank you.
Thank you. Mr. Guile?
No questions, Mr. Chairman. Thank you.
Thank you. Other parties? Mr. Ziegler.
Mr. Sullivan, I'm Belton Ziegler, representing SC DN. Just a couple of questions. I mean that. Yeah. In your testimony, you indicated, in your summary, you indicated that SC DN was only asking for approval of the merger, but no approval of rates. Is that an appropriate summary of what you said?
My summary says did not seek an increase in base rates.
It did not say increase, but it did present evidence in the application that it was currently under-earning its allowed returns and was seeking approval of regulatory provisions to deal with the N&D project and create a 3.5% reduction in rates, or keep rates as they are, depending on which plan you're dealing with. SC presented, did it not, all the information required for a rate proceeding for base rate adjustment, correct?
I would disagree with that because I believe under the plans it's to establish a capital cost rider, which is not an increase in base rates.
That's true in one of the three plans. But SC provided the full pro forma adjusted analysis of its income, rate base, and return for a rate to be set to establish SC&G's rates to be just and reasonable, correct?
I still disagree because the company did not request an increase to a certain ROE level. What it requested was a determination of the prudency for units 2 and 3 and recovery of costs associated with those units. I don't consider that an increase in base rates because base rates is an increase in rates associated with overhead and cost of that nature, depreciation. I mean, yes, this might have, some of those plans might have depreciation as part or amortization as part of the riders, but it's not for the entire company.
You would agree with me that SC filed under the appropriate provisions of 5827-860 and said that because no rate increase is requested, we're filing under the no rate increase provisions of that statute. You would agree with that?
I'm not a lawyer, and I'm unfortunately I'm not familiar with those statutes, and you confused me because you just said that the company was not seeking an increase, although you've
correct. But why don't we could agree that the application will show the basis of the request, and the application, not your testimony, will show exactly what the legal basis is for the request and what SCG is requesting, correct?
I'm not sure.
All right, so well, that's fine. I think we can leave it there. We'll let the application speak for itself. And you would also agree that when we look at the 2015 amendment to the EPC contract, it will tell us whether or not the fraud-related payments were part of the settlement, right?
I have some information with me on that, and it was a request we made of the company, and it does say that all claims are, let me pull it out. It says by way of further, this is part of the amendment to the 2015 EPC contract. It's section 3H, and it says the parties waive and settle any and all claims currently pending or threatened by either party against the other party. So I do agree that it was supposedly settled as part of the 2015 amendment to the EPC contract. However, you cannot find those exact costs as part of that settlement, and that's our. Out of no harm to ratepayers, that is why we've included that adjustment.
And that was an issue that was discussed at length in the 2015 case, that it was settled as a collective and not specific amounts for specific claims. Is that correct? You remember that?
I don't remember that because I was not part of the 2015 case, but I wouldn't disagree with that. That might have been discussed.
But the amendment, the order, and the proceedings in 2015 should answer that question, don't you believe?
Sure, if you say they will.
All right, very good. And I believe you said that you audited the quarterly surveillance reports that Ms. Griffin attached to her testimony and that were part of the record of the case?
Her testimony included, if I remember correctly, application used a 9/30/17 year. Her testimony then included a 12/31/17, and I performed no review, or the audit department performed no review of 12/31/17. It was so late in the process, there wasn't enough time to analyze that.
You don't have any criticisms of that particular document?
No, I mean, I still maintain that they're 12/31, although I don't disagree with the use of a historical test year. I've never disagreed with that. That there's certain information as of 12/31/17 that is not up to date as of today, and that's why I point out current.
The passage of time is your concern there.
Yes, and there's a lot of things that have changed since 12/31/17 to lower the ROE or increase the ROE.
I understand. And thank you very much. No further questions.
Thank you, Mr. Ziegler. Mr. Reed?
No questions, Mr. Chairman.
Thank you. Commissioners? Mr. Howard?
Sullivan, good afternoon.
Good afternoon.
Might expect this coming from me, but why didn't you go ahead and perform a traditional complete rate making case when you instead of just, I think in your words, you probably know. Why didn't you do a complete rate case?
It was not sought by the company. This was not
I know that.
a traditional rate case application. Therefore, we did
I know
not.
that, but just out of your curiosity and your affection for rate cases, I figured you might have gone ahead and done a complete rate.
No, sir, we did not. This was a unique case with a lot of other variables that we were not accustomed to. So rather than performing an analysis that was not requested, we concentrated on what was.
All right. When will the company be eligible for a rate case, regardless of the outcome of this hearing today? You know when you would be eligible?
I believe that's going to be dependent on the particular plan that is approved by the commission. Different plans had different stay-out provisions, and I'm sorry, I don't remember the specifics of each one. ORS Witness Link, Colin might address that in his testimony, or might be able to provide some information in regards to that.
You discussed bid rigging by some vendors. Could you discuss that?
That was the language used by the company, I believe, in their rebuttal testimony. Right. It's always related to a vendor that was submitting bids, from my understanding, from several different companies, but it was the same person submitting the bids to run the price up. I just want to clarify, this wasn't anything that SC&G is at fault at. They found this and they recognized this. The reason this adjustment was included is because it could not be determined based on the amendment to the EPC contract that it was actually removed as part of that settlement.
What was the amount?
The amount is $42,000.
What was the item?
It was office furniture, if I remember correctly.
Okay. Thank you very much.
Thank you, Commissioner Howard. Commissioners. Commissioner Urban.
Thank you, Mr. Chairman. Sullivan, could you or your staff provide the commission with a summary of the stay-out provisions of the various plans that have been offered? I think that might be helpful to the commission in our analysis.
Sure.
If that hasn't been done, we would like to have that as a late filed exhibit.
We can produce such a document.
Thank you.
Okay, that late filed exhibit with the stay out provisions will be exhibit number 49. Okay, commissioners, any other questions? Commissioner Howard, your light's still on, is that?
No, I'm reluctant.
Okay, thank you. All right. Mr. Nelson, any redirect?
No redirect.
Thank you. Mr. Sullivan, you may step down.
Thank you.
Okay.
Can we excuse Mr. Sullivan as well, Mr. Chairman?
As far as we know. Okay, we're going to take a break for about 10 minutes. We got a little technological needs we got to meet, as well as some biological. So we'll be back in 10 minutes.